Alright, this is the last video for the semester, and for this last video I wanted to tell you about what happened in my favorite negotiation with Professor Schwartzman. I think a lot of you, I think most of you for that matter, know Professor Schwartzman, and I think by now most if not all of you know that he and I are partners in a law firm. We have known each other for a long time, since we've known each other since law school, and we have been partners in a firm for let's say the majority of the years since then, which we're not gonna count because it sounds like too high a number, and I don't want to make him look old. From time to time we will work on cases together. And when Dan and I work on cases together, they usually have an environmental component to them, and they're usually litigation because I'm a litigator and he's the environmental attorney. There was a case some years ago we did where our clients owned and operated a car wash and gas station in the western suburbs, and they were having some work done out there. And the company that did the work had to do some digging, some excavating, and in the process of that, they punctured one of the underground pipes through which gasoline flowed when the tanks were being filled from the tanker truck that would come to refill the tanks. So they punctured the pipe, and of course this caused gas to come spilling out and contaminated the soil in that area. That was known right away. It was appropriately reported to the Illinois Environmental Protection Agency. The appropriate steps were then conducted, not only to report it to the agency, but to investigate it and to hire the appropriate companies to remediate it and remove the contaminated ground soil, repair the pipe, and get everything back operating as it should. Naturally, we then had a claim against the company that was doing that initial work and which punctured the pipeline. So we brought that claim, and we had contact with their attorney. It was agreed between all of us that we would sit down and try to get this thing settled. It was also agreed that since we're going to make a serious effort to settle this, that all the decision makers would be present. So Dan and I went to that meeting. I went as the lead spokesperson, the main negotiator, because that's what I do. Dan went so that when the time came to substantively discuss the environmental aspects or to answer questions that the other side might raise about the environmental aspects, he was there to do that. I might be doing some of it, but I might also well just defer to him and let him give the environmental professional answers. We also brought one of our clients along who had decision-making power in terms of being able to reach an agreement. When we got there, we discovered, and when I say we got there, we went to the defense attorney's offices. When we got there, we discovered that, of course, the defense attorney was there. The president of the company that had been doing the work and had punctured the gas pipeline was there, and someone else was there who we hadn't known was going to be there necessarily, someone from the insurance company. Actually, let me put it this way. We didn't realize that both someone from the insurance company and the president of the other company would be there, but okay, fine. We did know that some decision maker would be there from the other side. We then engaged in a fairly long conversation, a fairly long discussion about what had happened and and each side's view of what happened. It became clear, and they weren't really trying to hide it for that matter, that not only were we negotiating with them, but also that there was a dispute between the other company and their insurer. And so, in reality, there was a three-way negotiation going on. There was us vis-a-vis the other side, with somebody coming up with money. And then there was, on their side, a negotiation between the company and their insurer as to which of them was going to contribute how much to a potential settlement. They weren't giving us separate offers by any means, but it was clear that they had this issue going on. It also became clear that that was an impediment to our getting anywhere. They raised questions about, even though we knew that the pipeline had been punctured, how did we know that all of the soil contamination which was removed came from what they had done, as opposed to having been there from a prior spill or an accumulation of prior spills? And Dan fielded those questions based upon how much gas was flowing and how long it took and how widespread the contamination was, and we were sure we were making a very convincing case about things. However, and we made a demand for a certain amount of money. Basically, nearly all of the money that had been spent to investigate and remediate the soil contamination, as well as money for loss of business. All of that was a lesser component of our damages. And we made a demand for almost all of it on the basis of, we have a clear case here, but in order to get this thing done, we're willing to take some discount. They, on the other hand, were offering us a small amount of money, a small portion of what was involved, and they kept denying that we could prove our case. So we really weren't getting anywhere. And I was trying to use high realistic expectations, small systematic concessions, except there wasn't a whole lot of reason to even be making concessions because they weren't making up an offer to where we were really making any progress at all. So we got to a point where we simply weren't getting anywhere, and I think I indicated that. And at this point, Dan stepped out of his environmental expert role, which was okay because we had now reached this point, and said that he was really disappointed because he had really thought that with good faith on everybody's part, we would be able to come in there today and get all of this resolved because it was all quite clear. The facts were known to everybody, and there was really nothing to dispute. So Dan said that, and the response was sort of a look and a shrug on the part of the folks on the other side, which prompted me to do something which was in no way part of our planning. Dan's statement was not part of our planning. We hadn't anticipated this, quite frankly. But I was then prompted to look at the folks on the other side and to tell them that Dan meant every word he said because he's a very sincere, upfront kind of guy. But I, on the other hand, did not give a damn. I think I used language that was at least that strong, if not stronger. I didn't give a damn if it settled or not. Why? Because we would continue with the litigation, we would win, and I would make a lot more money. The lawyers would all make a lot more money because the litigation would be extended, And ultimately I knew it was going to happen. They punctured the pipeline. They were going to lose the case. We were going to get our damages. But I was happy to make more attorney's fees. That was fine with me. And then I said, so we're leaving. I got up, Dan got up. Our client, bless his heart, instead of looking at me saying, what the hell do you mean you don't give a damn, got up without saying a word. And as it happens, before we took 2 steps, the defense attorney said, wait a second, would you mind going into the next conference room and giving us a chance to talk? We said, sure, we'll do that. We did that. About 10 minutes later, they called us back in. And while we did not settle it that day, we did break the deadlock. And we did get on a path which led over a number of subsequent conversations that took some time, but not anywhere near protracted litigation. We did completely resolve it, and we got a good settlement for our clients. Now, you might view this, there's an old tactic which has become a stereotype tactic that almost everybody knows, good cop, bad cop, good guy, bad guy. One negotiator is the bad guy, one negotiator is the empathetic good guy, and it's such a cliche that it's very hard to pull off. And I suspect that if Dan and I had planned this, we couldn't have pulled it off. I think it worked out because, in fact, Dan was being completely sincere, and if I was not being completely sincere, I was at least following the stereotype of the completely cynical, in it to make as much money as he can lawyer. And that was believable, whether I fully meant it or not. So it worked. You may not have an opportunity, obviously, to do exactly that. But I tell you this story partly because I hope that it's interesting and entertaining for you, and partly to make the point that when you're at the bargaining table, while I've stressed planning and stressed planning and stressed planning, things happen that you don't anticipate. And you need to be able to think about what's going on, have a handle on what's going on, see the big picture sometimes, and when the opportunity presents itself, take it, and even sometimes, if you will, think outside the box. And if you get to do that once or twice and it works for you in your negotiating career, that's still going to be doing quite well. So I hope this was useful, and hope this was useful as well as enjoyable. Thanks.